Good afternoon, everybody. Boa tarde a todos. So before we start, I want to welcome Dr. Luísa Lourenço, a dear friend of mine, and I want to, together with Professora Marta Vicente, to welcome her to our Fundamental Rights lecture. We have the pleasure of having our dear friend with us, and I want to also welcome everybody who has joined us in a Friday afternoon to talk about fundamental rights. I know we all love fundamental rights, but this is a real love proof of our interest in this subject. And most of all, I want to thank Professora Luísa. I'm sorry, let me just turn this off. Okay. So before we start and before we give the floor to Dr. Luísa Lourenço, I want to briefly introduce her. So her CV speaks for itself, but she has an LLM from the College of Europe. She has a PhD in law from the European University Institute. She was a referent there at the Court of Justice, at the EFTA Court. She currently is a legal officer at the EU Chemicals Agency, and she has published several articles and has contributed in many conferences on the matter. So you couldn't be in better hands to learn about the scope of application of EU law. And so without further ado, let me give Luísa the floor. Luísa, the floor is yours, and thank you so much.
Good evening, everybody, and thank you, Benedita, for this very, very kind introduction. Indeed, well, as you said, I am currently a legal officer at the European Chemicals Agency, but just the caveat that I'm, of course, speaking here in my personal capacity today because this is a matter that, as you said, I've explored in my research, in my doctoral studies, and that's why I keep on having an interest in it. So thank you for having me, and I'll try to share my presentation. Let me know, please, when you see it. Let's see. Can you see it?
Perfectly.
Yeah, thanks. Sorry, it's just that I can't see anyone at this point. I only see my presentation. So the scope of application of the EU Charter of Fundamental Rights. Just to give you a brief structure of how I organize this presentation, which will be kept at a very sort of like basic level. We'll start by looking at the legal basis for the scope of application of the Charter. We'll look a bit into selected cases on the field of application of the Charter, so how the court has developed and interpreted the scope of application, the limitations set, and which criteria it applies in its interpretation. This will be case law post-Lisbon Treaty, because I think that at this point it's maybe better to stop talking about before, when the Charter was not primary law. Then we'll take a look at general principles of EU law very briefly, just because I think that this is a topic that is particularly dear to me, and I think that it's very interesting when talking of the scope of application of the Charter of Fundamental Rights, looking also at the other source of fundamental rights in the EU, which are the general principles. So I'll just take two examples of case law and try to explain which issues we see with it. Then we'll come to a few conclusions, maybe more than anything, food for thought for further discussion. So let's start then with the legal basis. Article 6 of the Treaty on the European Union tells us that basically the Charter has the same legal value as the treaties, so the Charter is primary law, and that the provisions of the Charter shall not extend in any way the competences of the Union. So it sets out limitations that will be addressed also in the horizontal clauses of the Charter. But what this means essentially is that, or the aim of the treaties by saying this is to say that the Charter is primary law, but it did not create human rights competence for the EU, which is detached from the competences held by the EU otherwise. So and we'll explore a bit more this bit of the connection with EU norms at issue later on. But so this is a point to keep in mind. I kept here also paragraph 3 of Article 6. We'll get back to this when addressing general principles, but just so that you see that the treaties state that fundamental rights shall constitute general principles of EU law. Looking at Article 51 of the Charter, which is called Field of Application, then we see here two things. First, the addressees in paragraph 1. So the Charter is addressed to the EU, institutions, bodies, offices, and agencies, and then to the member states only when they are implementing EU law. Then this paragraph 2 comes again to this issue of the competences, let's say. We'll get back to this particular wording, but it says that the Charter does not extend the field of application of Union law beyond the powers of the Union. It does not establish new powers, new tasks, or modify those existing in the EU. So this is our legal basis. This is where the court will also depart from to develop its case law. So let's look then at the case law. I've decided when doing this to just bring a few cases, as I said, and to unpack the sentence, or the bit of the sentence addressed to the member states only when implementing EU law. And even though it's kind of the other way around, let's start with this second bit, only when they are implementing EU law. What does this mean? The Fransson case, in this case, Mr. Fransson was a self-employed fisherman in Sweden, and the Swedish tax authorities accused him of having infringed its obligation to declare VAT because he would have incorrectly reported his income, and this resulted in a loss of revenue for the authorities. On the other hand, a few years later, the Public Prosecutor's Office brought proceedings for tax evasion against Mr. Fransson. So what happens here is that we have the same action giving rise to two separate types of penalties, and this would potentially go against the ne bis in idem principle as enshrined in Article 50 of the Charter. So, was the Charter indeed to be applied here? Was this within the scope of application of the Charter? Let's then see what the court did. The court starts by saying that fundamental rights are applicable in all situations governed by EU law. This means that, and the court refers here to the explanations of the Charter, that where national legislation falls within the scope of EU law, the Charter will be applicable. So, applicability of EU law will entail the applicability of the fundamental rights guaranteed by the Charter. On the other hand, the court continued, if the situation does not fall within the scope of EU law, the Charter provisions cannot on their own form a basis for the court's jurisdiction. So we see here all situations governed by EU law, the fundamental rights protected at EU level are applicable, but on the other hand, it's not enough to have a Charter provision. We need the situation to fall within the scope of EU law. And this is particularly important for the bit of the sentence, the expression implementing EU law, because it shows us that it is not only implementation stricto sensu, it's not only when the member states are acting as agents of EU law and are implementing, for example, a directive in the national legal order. The court refers here to the scope of application of EU law, and this means that, and in line with previous case law, the ERT case law, that derogation situations are included. So when the member state is derogating for, say, a fundamental freedom, this is also considered to be EU law implementation. So what did the court do? What did it say in this particular case? It said that here there's a direct link between the collection of VAT revenue in compliance with EU law, with the EU law applicable, and the availability to the EU budget of these VAT resources. Because there's an impact in the collection of VAT in the resources for the EU budget. So the fact that the national legislation at issue had not been adopted to implement the particular directive could not render this ineffective. So because the application of the national legislation was in fact penalizing an infringement of the directive. So it intended to implement the obligation imposed by EU law and safeguarding the financial interests of the Union. So here we see this direct link between the norms. We move on to a different case, to Julian Hernández. At issue here was a series of employees that had been dismissed by their employer, and this employer was later declared insolvent. So according to then in Spain, this was the member state at issue, the Spanish Guarantee Institution had paid compensation for this dismissal, but it had denied outstanding remuneration, and this was the remuneration that went above the 60th working day following the date of start of the proceedings when the dismissals were commenced, because the national legislation said that this was a case of an invalid dismissal, and the national legislation at issue would apply only to unfair dismissals. So the employees had brought this case and had invoked the principle of equality enshrined in Article 20 of the Charter. The court, however, said that this national legislation was not intended to implement provisions of EU law. When looking at the EU rules in the area, it said that EU law does not contain... sorry, I think that someone hasn't muted themselves, so I'll continue. So if EU law does not contain any specific rules in that area or any rules that are likely to affect the national legislation, the Charter cannot be applicable. And again, in this latter bullet point, there was no interpretation or application in the situation issue of a rule of EU law other than the Charter provisions. So there was a reference to Article 20 of the Charter, but there was no other EU rule at issue. So the court stated that this was not a case of implementing EU law, that this was not within the scope of application of the Charter. These limitations and the criteria were further developed in the Siragusa case. Very briefly, again, this at issue was an Italian decree. This property owner had built certain works in his own property, and there was an Italian decree which required him to restore the site to the former state because it considered that the works were incompatible with the national landscape conservation rules. At issue here was then the right to property, enshrined in Article 17 of the Charter, and the national court had suggested that EU law should be applicable to the case because landscape protection, and so landscape conservation rules, could not be seen as a concept which is separate from the protection of environment, and there are a number of EU rules on environmental competence so for the Union. So the National Court asked the ECJ whether this would be the case. And the court stated that this implementing EU law should be read as requiring a strong degree of connection that goes above and beyond the matters at issue being just closely related or there being an indirect impact from one matter onto the other. Then the court proceeded to lay down the criteria, which are still now used in the subsequent case law, to analyze whether the situation falls within the scope of application of the Charter. Is the legislation intended to implement a provision of EU law? Is the nature of that, what is the nature of that legislation? Does it pursue objectives other than those covered by EU law, even if it's capable of indirectly affecting it? And are there any specific rules on the matter or rules capable of affecting it? So these would be these would be the threshold criteria to assess whether the situation falls within the scope of application of EU law. In this particular case, the court found that fundamental EU rights could not be applicable because the provisions of EU law in this area did not impose an obligation on the member states with regard to this specific situation at issue in the proceedings. Finally, here, a more recent case, the TSN case on paid annual leave, enshrined in Article 31(2) of the Charter. Here we have a case where there was a collective agreement which laid a longer period of paid annual leave than the directive. The directive prescribed a 4-week period, and there was a breach of this provision of the collective agreement. And the question was whether the right to paid annual leave was violated by this. The court said, however, that it is not enough then for domestic measures to come within an area in which the EU has powers. Because in the case at issue, the provisions of EU law did not impose a specific obligation. Hence, the situation did not fall within the scope of the Charter. In this case, the directive established 4 weeks of paid annual leave. It did not preclude higher standards, but once the member state adopts those higher standards, that bit that goes beyond the directive is not a measure of implementation of the directive. And here we see the court basically having difference to member states in areas of minimum harmonization. So EU law imposes certain criteria. Then what goes beyond is for the member states. It's not implementation of EU law. This bit then on what implementing EU law means. But if we go a bit before, the question of individuals and private relationships, do they fall also under this Article 51(1) of the Charter when it says that the Charter is addressed to the member states? And here, with this case, Bauer and Willmeroth, it's 2 joint cases concerning, again, the right to paid annual leave in Article 31(2) of the Charter. And this is particularly interesting because these 2 cases are, one of the cases covered a relationship between a public authority and an individual, while the other case was between a private employer and a private individual. So we have vertical situation and a horizontal situation. However, we'll not explore necessarily this, but this at issue was a refusal to pay a compensation for annual leave not taken to the widows of 2 employees who had deceased. And well, the court will say here, it will go into the nature of the right to annual paid leave, but what I wanted to focus on here for the purposes of the scope of application is that the court states that the fact that Article 51(1) does not say whether individuals may be required to comply directly with it doesn't mean that this is precluded. So what the court says here basically is that Article 51(1) says member states, but individuals may also be covered in their horizontal relationships. So by not stating anything against it, the court interprets this provision as meaning that this possibility cannot be precluded. So it says that the Charter can have horizontal direct effect. This will depend, of course, on the nature of the right or principle at issue, but this is not excluded. A conclusion at this point on the scope of application of the Charter, we saw here that as developed by the court, the Charter will be applicable when member states act as agents of EU law, so implementing EU law stricto sensu, also when member states are in derogation situations, when they derogate from EU law, say a fundamental freedom, and also a bit more nuanced maybe when there are specific EU rules on the matter that affect, in a matter that national legislation affects EU law, but there must be this direct link between the pieces of the legislation. What I would like you to retain mostly from this is that we're talking always of the validity, the interpretation, or application of another norm of EU law. Another norm must be applicable in concreto to the case. It's not enough that there's a theoretical possibility. It's not enough that there's a charter provision. There needs to be another norm for the charter to enter into application. And as you saw now with the Bauer case, the latter bit, the charter may also have horizontal direct effect. Let's move into the messier bits. General principles of EU law. Very, very briefly, because there are books on general principles of EU law entirely, so one could not cover this, definitely not with one slide. But to give you a brief introduction to what they are, they're non-written sources of EU law. They have been developed by the case law of the court, found in national constitutional laws and traditions or international instruments like the European Convention on Human Rights. And in terms of functions, they have been used by the court as a condition for the legality of secondary law, as aid to interpretation of other provisions, or to fill normative or substantive gaps in EU law. The treaties, as we saw, Article 6.3 of the TEU states that fundamental rights should be protected as general principles of EU law. And here we see that indeed the treaties refer to two sources of fundamental rights in the EU, the Charter and general principles, with no clear hierarchy between these sources. And this, as we'll see, will become problematic. One must also remember that there are general principles of EU law that go beyond fundamental rights. Indeed, general principles are kind of, they pervade the whole of the EU legal order, have the general principle of legal certainty, proportionality, good administration. General principles, the case law is fertile in the area, for example, of public procurement. So when talking about general principles of EU law, it's not only fundamental rights, but fundamental rights are protected as general principles. So here, the question is, if we have the Charter, what is the role of general principles then? Do they have the same scope? Do the systems overlap? Or do they go beyond, and what is the problem? And here, I've just isolated two cases of the court, and I've decided to bring them just to look at them without going into the facts, but just to look at the type of norm combination that the court uses in its reasoning. First case, Egenberger. This preceded the Bauer case in establishing the horizontal direct effect of the Charter, as you see there in this part that is underlined. But what I wanted to draw your attention to is that here, the principle of non-discrimination on grounds of religion or belief, the court frames it as mandatory as a general principle of EU law. Then it states that that prohibition is laid down in Article 21.1 of the Charter. So the reference to the general principle precedes the reference to Article 21. We see that the reasoning is also, again, on the same principle of non-discrimination on grounds of religion or belief. In the RR case, the court first says that before the Treaty of Lisbon, the principle derived from the common constitutional traditions of the member states. This has been a long case law of the court on general principles, as I said before. The Charter had this primary law value. But again, here the court says that the prohibition is enshrined in Article 21 of the Charter and is a mandatory general principle of EU law. And it is this quality as general principle of EU law that then we see in paragraph 71 takes the court to say that the legal protection which individuals derive from these general principles entails a disapplication of national law if the national law provisions are contrary and cannot be interpreted, and would somehow, their application would hinder the full effectiveness of the rights. What is the problem? In the case law, the general principles have been now referred before the Charter provision to reach this horizontal direct effect conclusion, so this application between private parties. the court refers to this mandatory general principle of EU law. Is this a way to bolster fundamental rights protection? Are these, on the other hand, to be seen as parallel systems of protection? If so, then the scope of application question also enters. Is the scope of application of general principles somehow broader because it wouldn't be limited by the horizontal clauses? In addition, both these sources can be used as aid to interpretation and grounds for judicial review, but it is the role of general principles to fill normative gaps. In addition, one should recall also that some rights in the Charter are not general principles of EU law, because throughout the case law, the court has sometimes refused to give this status to certain rights enshrined in the Charter. Some of the rights have been considered mandatory and unconditional, enough to lend themselves even a horizontal direct effect, but some other rights are not. And then, of course, general principles are naturally more vague, and the Charter rights tend to be more defined, particularly because they are written sources. So are then general principles a tool for new fundamental rights to be recognized in the EU, taking inspiration from international instruments? And here Article 3 could be seen then to guarantee that their role would not lose relevance. Conclusions. Well, let's say maybe it's one conclusion and 2 bits up for discussion. First, and this is really what I would like you to retain from this matter of the scope of application of the Charter, is that there must always be another norm of EU law at issue. The fact that the Charter has a right that one wants to invoke is not enough. There must be something that anchors the application of the Charter. And in this, I chose this quote by the President of the Court, who says that the Charter is the shadow of EU law, and just as an object defines the contours of its shadow, the scope of EU law determines that of the Charter. And I think that this is a good image that will help you when thinking of the scope of application. Then we also saw that once a situation is deemed to be within the scope of the Charter, the Court does not exclude that it might have horizontal direct effect, that is, applied between private parties in private relationships. Then on this last part, on general principles, there's still quite a lot of uncertainty between the scope of application of the Charter and that of general principles. In my personal view, having the Charter, which is now primary law, fully fledged primary law, as a main source of protection would probably enhance legal certainty and make the operation of this fundamental right a bit easier, and still leave role for general principles to fill substantive gaps if need be. But of course, this is to be seen, and I would recommend here, if you want to read a bit more on the issue, there's an article by Emily Hancock's the Cambridge Yearbook of European Legal Studies from last year, which is quite good on the relationship between the Charter and general principles, where she lays down the different possibilities for their interaction. So if you want to read more, you should go to this article. Thank you very much, and I'll be happy to discuss and answer if I manage any questions. Thank you.
Thank you so much, Luísa. This was a wonderful lecture. Students this week have learned a tiny little bit about the scope of application of the Charter, but I think right now we are all enlightened with your presentation, and I'm also sure that there will be many questions. And so I will, I have my own questions, but I want, of course, to give the floor first to our audience. And let me ask if any of you have a question, which is very much encouraged, as you know. Raise your hand and I'll give you the floor, okay? If not, I'll just use my prerogative and ask my own. João, you're formulating. Okay, take your time. No worries. Anyone apart from João who's having trouble formulating a question, but I'm sure there will be a good one. No, so let me ask my own question then, okay? And then maybe you'll have formulated your own afterwards. So Luis, I was thinking, like, while I was reading, I was thinking about an issue, and I was thinking about discrimination, basically, not the principle of non-discrimination. And so I wonder how one conciliates the apparently closed list for grounds of discrimination enshrined in Article 19 of the TFEU with the, let's say, open grounds list of Article 21 of the EU Charter of Fundamental Rights. How does one conciliate these two provisions? I don't know.
Well, it's a very good question. Let's see if I manage to say something about it. Thanks. Well, I mean, this is, of course, a discussion that has been happening as well, but Article 19 of the TFEU is a competence clause. And as a competence clause, it indeed allows the Union to take appropriate action to combat discrimination on, as you said, an exhaustive list of grounds of discrimination. And indeed, Article 21 is open-ended, but Article 21 of the Charter is not a competence clause. And it doesn't give the Union power to enact any anti-discrimination laws. The court has used this in its reasoning in the Kaltoft case when it referred to, well, that there was a claim whether there would be a principle of non-discrimination on grounds of obesity. And the court said that the fact that there was no legislation, that this ground was not mentioned in Article 19, and that there was no legislation enacted to protect this ground, it meant that there was no competence and that this would fall outside the scope of the Charter. So it would seem that the court is trying to say here that indeed we're not trying to circumvent the competence clauses. But we also saw that the wording between the Article 6 of the TEU and Article 51 of the Charter is a bit different in terms of competence, powers, etc. And even if, if the ground is not listed in Article 19, indeed there is no competence to legislate, but what if a situation somehow falls within the scope of application of EU law for some other connection, and then there is a ground that is not named there? Will it not be protected? Because the EU will also, apart from using its legislative competences, the EU might be acting in other ways, and it should not discriminate on any of the grounds. So I think that it's clear that there's a bit of a mismatch there, but there are two different things, and I still think that there's leeway for an interpretation of Article 21 that would allow it to have this open-ended list of grounds. I hope that replied a bit.
Great, thank you so much, João. So you had I think, enough time to formulate a question. Go ahead.
So my question is, I would believe so, it's more open-ended, but it is in the sense of, okay, now that we have the Charter and it's now primary law, and looking at Europe of today, so I'm thinking directly of the rule of law crisis. Can we see the Charter, if in its evolution, it can start to be applied more without having to sustain itself on other pieces of your law, being it a directive or treaty precepts? Could we see it as the driving force of more political cohesion and in a way to save Europe?
It's a difficult question. Well, I think that it's very clear that the way it has been drafted, the Charter, and the way the court has been interpreting it, I don't think that there's that much space for the Charter to be applicable per se. Without having this anchor on other legislation. Of course, I think that the situations, there might be situations that arise where protecting a fundamental right goes beyond these things. And I'm just thinking of, for example, what the court has referred to effective judicial protection and the rule of law in Associação Sindical de Juízes Portugueses. So there might be a role to play. And if we think of the protection of values as a core of EU law, sure, but I have my doubts that it would be possible to do it without a big change in terms of the treaty, the way they have been drafted, or the charter itself.
Thanks a lot, both. João, great question. Beatriz, you also think it's a great question. So I wonder, do you have your own question? Thank you, Luísa, for your answer. That was great.
Hello. Sorry, I can't do it now because I'm in the middle of traffic. So, but I think it is a very good question. And I think lots of great minds are still wondering about it.
Yeah, the role of the charter.
I think no, that it can be applied directly without any other support. But I have no particular question for the moment. But I can ask, is it possible that there will be any change to Article 51 of the Charter, or if it will be abolished? That's my question for now to release the debate. Thank you.
Thank you, Beatriz.
Yeah, no, I mean, I don't have a genie in a bottle to answer that. So, but yeah.
Thank you. No. I think that would be in another life, in a parallel life.
I don't think I particularly think that politically, no, it wouldn't happen.
Especially within the current context, political context in the EU. I think less and less this type of changes are realistic. I don't know if you agree with me, but treaty amendments right now.
Yeah, I don't think
to make the charter more applicable sounds like a dream. Anyway, any other questions? Does anyone want to participate, even with a comment, anything? I think they're shy, Luísa. I think they're saving their questions for when they leave the event.
Well, it always takes a bit of time to digest the scope of application of the charter. I understand.
I have to teach it. I really have to digest it before I teach it. So,
Professor Benedita.
Professor Martha, tell me, do you have a question?
Can I also ask a question? It is not directly linked with what Professor Luísa explained us, but I think I wonder whether there are some market freedoms that are also fundamental rights under the Charter. And I wonder whether there is some advantages in those market freedoms being also enshrined in the Charter, or it doesn't make any difference because the market freedoms are already deeply protected under EU law. So the fact that they are also fundamental rights doesn't mean much under EU law. That's my question.
Thanks, Martha. I'm not sure. Oh, well, the market freedoms, they are in the treaties. So in that sense, they were already primary law before the Charter received its primary law status. I think that the advantage of having this codification in the Charter for everything really is that it makes more visible the fundamental rights vocation also of the Union. As I said in the beginning, it's not like the Union now became a human rights organization, but it shows that these values, they are deeply important, and that it shows that by having a charter, by having this type of constitutional, if you want, type of document, that these things gain more visibility. And when national courts also look at the interpretation of certain national principles, they might look into inspiration from the Charter. So in that sense, having things laid down in this way might make a difference, But as I said, in terms of legal value, I'm not sure whether it makes for the particular case of the fundamental freedoms that much difference.
Thank you.
Luísa, I think.
Yeah, it's supposed that this article on the relationship. It's called "Relationship Between the Charter and General Principles: Looking Back and Looking Forward." It's by Emily Hancock's Cambridge Yearbook of European Legal Studies from last year.
I think Emily was here with us. I don't know if she's still here. Yeah, Emily's a dear friend of ours, so I think she's not anymore. She might have left, but she's hi, Emily. Katarina, you raised your hand. Go ahead.
Thank you.
Catarina Ferreira. Okay. João, you raised your hand again, so go ahead.
Yeah, I got another question because I was looking at Article 51 and when I read agencies, I remembered, for example, Frontex, and I started to tie it back to the migrant crisis. And my question would be, being that Frontex is a European Union agency, does the charter in itself have relevance, for example, to the migrant pushbacks and the current situation in Italy and Greece?
Well, I mean, of course, in the sense that, we were discussing the scope of application of the Charter in relation particularly to member states when implementing EU law. But as the article said, and as you correctly note, the Charter is applicable to the Union in its actions. So yes, any Union action has to be informed by primary EU law, which is the case of the Charter. So yes, would be the answer, in my view.
Hopefully. That would be amazing. Anyway, Katarina, I don't know if your hand raise is a mistake. Sometimes it happens. If not, I wonder if there's anyone else. Professor Isabel, good afternoon and thank you for joining us.
Sorry. Hello. May I ask a question? So Professor Benedita, Professor Luísa, thank you very much for your lecture. I arrived a bit late, but thank you very much. I teach in public international law, and I'm teaching, I believe, some students that are here. We are studying public international law, and I wonder, maybe this is a bit out of the scope of what you were expected to discuss, and if that is the case, I'm sorry, but I'm sure you can give us some idea, and I'm sure you have thought about this. And when we discuss the Charter of Fundamental Rights, I always wonder if this has influenced the process of accession of the EU to the European Convention on Human Rights. So this is still in the treaties. This is one of the case studies that we study regarding the conventional capacity of international organizations. And I always wonder, this is not just a strictly legal question, because I wonder if this evolution, which is a positive evolution, at the same time in the relation between the possibility of the EU to assess the European Convention, does not raise some obstacles, some practical obstacles, and is not a political obstacle to this development. And I wonder if you have any idea, or you can discuss. If this is out of scope, sorry, Professor Benedita, but I was just enthusiastic to hear some other thoughts on this, and maybe more from an EU perspective than from a pure international law perspective. So thank you very much. And thank you, Professor Luísa.
Thank you for the question. It's a very interesting question. I'm not sure I'm qualified at all to reply to this, but I think that the problem with the accession has been, I mean, of course, the Charter, as the fundamental rights case law of the court before the Charter has primary law value, has always been deeply anchored in the rights read exactly like in the European Convention on Human Rights. So in that sense, it's not like the rights protected by the convention cannot enter the interpretation of the charter. But of course, this accession issue, which has been an issue for a long time, I think that the problem there, it's not really the content. The problem is the jurisdiction. And as you know from the opinions, that because the Court of Justice is not really keen on, and this of course poses real problems, because then if you submit the jurisdiction of the court to another court, then you'll be in maybe uncharted territory. So I think that the problem is more this problem of the jurisdiction and of the way let's say the institutional architecture of the Union would survive the accession to the convention, and that's probably why it hasn't happened, to be honest.
Thank you so much.
Thank you.
Luísa,
Thank you very much.
Thank you for this wonderful debate and interdisciplinary. We always love public international law joining in EU law. And so, Katarina, you have a question. Just turn on your mic and go ahead and ask the question.
Teacher, I have no idea what's going on and why my name is appearing as Katarina. I have no idea. I think it's because she sent me the link, and maybe that's what's going on.
Okay.
I was raising my hand and I was seeing Katarina raising her hand, and now I got it. I'm so sorry.
Okay.
I have a question. I would like to know if you think that the charter already protects everything that it should protect, or if it still has some room to grow as we as an European community grow as well.
It's difficult to say. I think that the charter has been made, it's quite comprehensive. If you think, for example, in this discussion we refer to Article 21, the number of grounds of discrimination. There's also non-discrimination on grounds of wealth, of like genetic heritage. I mean, it's quite comprehensive, but of course, with the evolution of not only the legal order per se, but also things with artificial intelligence, all these sorts of new developments, I think that there's always space to grow in this sense. And I think that the charter will benefit then in that case from the general principles, because then the court will be able to interpret, let's say, and again in this Article 21, the list of grounds, since it's open-ended, it lends itself to more grounds that could eventually show up. So I think that there's space definitely to evolve.
Thank you so much.
Thank you both. Thank you, Beatriz, for not giving up on asking a very interesting question. And thank you, Luísa, for your answer. Miguel, go ahead. Hello, Miguel. Thank you for joining us.
Hello, Benedita. Hello, Professor Luísa. Thank you very much for this very clear and informative lecture. It took me a while to think of a question because it was so clear. And it's a question that's not really about the scope of application of the charter, but rather on the role that the charter can have in the interpretation of treaty provisions. And this question came to mind in light of the recent Consorzio Italiano management judgment, where the Court of Justice clarified its Silfi case law. And one of the most interesting aspects of the reasoning of the court in that case, for me, was how it interpreted Article 267 in light of Article 47 of the Charter. And I find this to be a very interesting function to the Charter. The first time I read this, I almost thought it was almost positioning the Charter as above the treaties, something that treaty interpretation should be conformed with, which from a hierarchy of sources perspective doesn't make a lot of sense, but perhaps from a hierarchy of norms would. And I would love to hear your thoughts on this point.
Thank you, Miguel. Great to see the EUI there in the background. Yeah, I mean, this is a tricky question. I wouldn't say that. I think that this issue of the effective judicial protection, it's quite a particular issue now lately in the case law, in light specifically of the rule of law discussion. And as I mentioned, this was already the case with the Associação Sindical dos Juízes Portugueses, and of course, I don't think that necessarily this is putting the charter above the treaties. I think that the charter has the same value as the treaties, right? It does not extend the competences, doesn't extend the powers, but it has the same legal value. General principles have the same legal value. So I would say that here it is, the court does what it has done in many instances. It uses a combination of norms to achieve the result that it intends to achieve. And so I would say that these fundamental rights that are now written down in the charter, they had been protected before. This is also why the horizontal direct effect of the charter is not really, I mean, it might be difficult for certain rights and certain principles concretely, but it's nothing new. If you think of the Defresne case in the 70s or Angonese in the 90s, the court said that treaty provisions had horizontal direct effect. So this is all now, in my view, it's a matter really of having three sets of norms that are in the same line, and they will, the court particularly in its case law will use them in combination. I don't know if this replies to your, it's a very delicate and very difficult question, but at least these are my ideas on the subject.
No, absolutely. It truly does, and I think you're absolutely right. I think in the end, it's an issue of more of combining norms to find a judicial result. On the comparison with the Defresne judgments, it's true that those horizontal treaty provision cases, they were rather specific because they related to issues where you have these private parties that were exercising powers that were very close to public powers of collective regulation of labor in the case of the Defresne. And what we're seeing with, for instance, the Bauer judgment, it's not that. It's really just a private employer and his relationship with the employee. But yeah, so definitely, it seems that there is a lot of uncertainty, and there's still a lot to develop.
Yeah, and this of course creates quite a lot of issues because, you know, as a private entity, as a small employer, how can you be expected to know that there will be this type of effect? So I mean, it is complicated, and it also is, in my view, even more complicated if you think, because still these, the Bauer case, the Egenberger IR, these are cases that relate indeed to employment situations. But what if we go to rights as the right to privacy, the right to family life? Then how can we enforce this in private relationships? Yeah.
Thank you both. I think this is a very interesting question, and I think there's something to be said as well about the way the court has been using the charter within the line of cases of the rule of law. So, for example, you already mentioned Associação Sindical de Juízes Portugueses. I was already on a rant about Associação Sindical de Juízes Portugueses this week with my students, but the court didn't really need to consider that the case was admissible. The court could actually have found a very good justification not to look up the case, and the court chose to do that. And actually, if we look deeper into the jurisprudence of the court, in particular with regards independence, we can see, I don't know, this is just me thinking about it, but when we look, I wonder if this is not because we're touching on the issue of judicial independence. If this type of, let's say, reasoning of the court, look at Banco Santander S.A. So basically we are reconfiguring Article 267 of the TFEU and rethinking what are like basic concepts of EU law, such as courts and tribunals, and that touches upon independence, and that now relies as well on the charter because it's connected with Article 47, it's connected with Article 19, and so one might think like we are kind of, let's say, rethinking and reanalyzing basic concepts of EU law in light of the rule of law. And so, I don't know, this is something just that I've been recently thinking about, and I think there's at least something to be said about the way the court is using the charter within this line of cases, whether if it's innocent or not. I don't know, I don't work for the court, so I can say these things. Anyway, thank you so much. Are there any other questions? Any comments, questions? If not, I just want to thank you. I just want to, when we must thank Professora Luísa, and I want to deeply thank you for joining us again in another fundamental rights lecture. This is already a tradition. And thank Professora Marta, Professora Isabel, Miguel, everybody who joined in, all the students who ask questions. You just make the event worth it by participating. And hopefully, let's see you next week on other public international law and EU law events that we have next week on Tuesday and on Thursday. So quite busy on this matter. So I hope to see you all there and have a wonderful weekend. Okay, so bye-bye. Thank you very
much for having me.
Bye.